Thank you all for the opportunity to talk to you again today. And what I'm going to talk about is the role that law, particularly the law of the sea, plays in the at-sea part of the regulation and support of the maritime trade and maritime industry. This role cannot be understated. What's more, there are a whole range of other bits of law, international law in particular, that relate to or regulate maritime trade. But they're of less immediate concern for us when we're thinking about the topic of today's seminar. For example, think about the incredibly complex set of rules that governs international trade and investment law. I'm not going to talk about that. There's an equally complex set of rules that governs the maritime industry internationally. I'm not going to talk about that. There's also other rule sets that govern trade by sea in special circumstances, such as armed conflict. And indeed, a large proportion of the law of naval warfare and the law of neutrality is precisely about how warships interact with neutral merchant vessels, neutral merchant crews, and neutral cargo, and enemy merchant vessels, crews, and cargoes. But my focus today is really on routine or peacetime regulation of trade by sea in terms of how the law of the sea and defence interests intersect. So to this end, I'll really just talk briefly about two maritime trade, law of the sea, defence interest intersections that I think are of interest. One is very current and one I think is quite critical. Now, the first is how the law of the sea regulates trade through strategic choke points. And for this, I'll use the Straits of Hormuz as an example. And my bottom line on this issue really is the rules are pretty well settled, but when you add in the active merchant vessel escort and protection measures equation, there are still some areas of legal debate. The second issue, however, is much more problematic, and it's been addressed briefly today by Stephen, and Richard's raised the issue, and Peter's spoken to it briefly as well. And I really do think we need to do some evolved thinking on that pretty soon. And that issue, of course, is the protection of undersea data cables. And these have significant defence implications in terms of protection measures, possibly, by maritime forces of the economic and security vulnerability that they represent. And my points, I guess, in relation to this second issue are these. First, we need to get to grips with this vulnerability pretty soon because there is absolutely, almost, no regulatory regime over this vital piece of international infrastructure. And second, we probably need to do some thinking pretty soon about what a rule set that does provide a regulatory regime and a protective regime over this international infrastructure might look like. All right. So the first issue, the law of the sea and routine trade by sea. If we use the Straits of Hormuz as a case study of how the law of the sea manages critical choke points, what's reasonably clear is that the law of the sea in particular, has a pretty good handle on things as we speak. What's well settled? Well, the law of the sea tells us, for example, that we know what sort of choke point the Straits of Hormuz is. It's a strait used for international navigation. We know that vessels have a right of transit passage through these sorts of straits used for international navigation. The law of the sea also tells us that this transit cannot be hampered by the coastal state and that it's non-suspendable. The law of the sea then goes on to tell us what sorts of things the coastal state can regulate in these sorts of straits, and is a traffic separation scheme okay? Yes, the Straits of Hormuz is a classic example of that. Are rules about environmental protection for transiting vessels okay? Yes, the coastal state can do that. Is it okay for the coastal state to put specific SOLAS and navigational safety hazard avoidance regulations in place? Yes, that's okay. Prohibitions on research and survey? Yes. Prohibitions on fishing? Yes. But that is the list of things the coastal state can lawfully regulate in a strait like the Straits of Hormuz. So it's actually quite targeted and quite limited. And this reflects the underpinning predisposition of the law of the sea to facilitate rather than hamper trade. But there are some lingering uncertainties. There are some areas of debate that still exist, and these have a direct relevance for defence in terms of merchant vessel protection operations. For example, it is a strait used for international navigation, but beneath that, the status of the waters is still as territorial sea, in this case of Iran to the north and Oman to the south. So does this underpinning status limit in any way the overlay of the international strait in terms of security authorisations? How do we manage the in-strait disputes around where the lines in the water are between Iran and Oman, for example? Because that can impinge upon how you carry out your security assessments and your assessment as to whether or if you should use force in defence of a merchant vessel. How do we resolve disagreements around the applicable legal regime itself when one of the Strait states doesn't agree? So, for example, Iranian claims about the detention of the Steno Impero, this vessel here, varied over time from it being about security to the claim that it turned its AIS off, its automatic identification system, which is not actually a crime, that it crossed the TSS lane incorrectly, that it collided with an Iranian fishing vessel, and there was also a question about whose waters it was originally given direction in. It seems it was probably inside Omani waters where Iran was giving it directions. But I think the most immediate area of lingering legal dispute is around the use of force in defence of merchant vessels. So is such use of force an instance of individual and unit self-defence of the merchant vessel and the crew? If so, what effect then does the fact that the merchant vessel flies a different flag have? Or is such a use of force actually an incident of, brackets collective, national self-defence in accordance with UN Charter Article 51? That is defending the merchant vessel actually defending the state whose flag it carries? Now, if this is the case, then how central is a pre-authorisation from that state in order to exercise that act of self-defence over that merchant vessel? Then we have to think about, well, what is the implication of using force in defence of another state, in this case as personified by a merchant vessel carrying its flag? What does that do in terms of creating a legal relationship of hostilities, perhaps even of armed conflict, between us as the defending state and the state that has acted against this third state merchant vessel? The case law on this is very scarce and it's very inconsistent, but it does seem to say that the coastal state, use of force by a coastal state against a merchant vessel does not rise to the level of an armed attack, which is the trigger we need to activate Article 51 national self-defence. And that would in turn mean that what international law says is that when a merchant vessel suffers this, that the proper response is what's called a non-forcible countermeasure. That is an unlawful act, but not one that involves the use of force. Unless, we decide that there is also a separate right to defend the merchant vessel as a unit and the people in the merchant vessel as individuals, which case the right of self-defence for them is different to and separable from the right of self-defence that attaches to the flag. Now, the second issue, I think, which has been raised by a few people today, this is much less well regulated, but it is a deeply challenging trade by sea issue. And in 1982, when the Law of the Sea Convention was finalised for signature and ratification, it didn't really exist on the scale that it now does. The modern economic and security vulnerabilities represented by the Undersea Data Cable Network cannot be underestimated. So a little bit of history. At the outbreak of World War I, and Matt Buckley referred to this a little bit just briefly before, in August 1914, one of the first acts of both sides was to cut each other's seabed-laid telegraph cables. The Germans cut the one that linked the UK to the US, and the UK cut all but one German undersea telegraph cables. That one they left live and they tapped it, and from that tap they intercepted what was known as the Zimmermann telegram, which is one of the ways that the US was brought into World War I against Germany. So what are the vulnerabilities? It's as simple as this. More than 99% of international data traffic is carried on the undersea cable network. 1%, less than 1% is actually carried by satellite. And that 1% is very important because it puts the timestamps on the data packets, which allows them to be reassembled at the other end. But the bulk of it, 99%, the data itself is carried on the undersea cable network. I want to give you another comparison. Trade passing through Australian ports each day is estimated at about 1.2 billion Australian dollars per day. That's a big figure. By comparison, 10 trillion US dollars in transactions occur every day across the undersea data cable network. 10 trillion. So this makes it probably, as you can imagine, the most fundamental item of international critical infrastructure that you can think of. There are also innovative future proposed uses of the undersea data cable network, including the use of the data cable network to control, communicate with and send messages to autonomous underwater vehicles. So there's a whole range of existing and impending economic, trade and security vulnerabilities that link up with the maritime undersea data cable network. Yet data cables, unlike satellites, have no nationality, and there is no regulatory guardian in the same way as there is for satellites. This means that interference with data cables is to a large extent much like espionage. It's unfriendly, but it's not unlawful in international law. A few months ago, you might have remembered that there was a media report about a fire in a special purpose Russian submarine called the Lashari, which tragically killed a number of sailors. The details of the submarine, Russia said, are a state secret, but it's widely understood that this submarine exists to deploy specialised data cable tapping and cutting technology, and it's assumed that many other states have this capability as well. So if I wanted to know, if I were a state and I wanted to know where the next big technologically enabled threat from the sea to my peace, good order, trade and economic well-being was coming from, I'd start looking at undersea data cables and the almost total absence of protective regulatory and security control and ground interference with those data cables. So what is that current regulatory regime? It's not very strong. There are some brief Law of the Sea Convention references to the high seas freedom to lay undersea cables. There are some references, Articles 113 to 115, which talk about the jurisdiction over someone who cuts your undersea cables, damages your undersea cables. That jurisdiction is entirely perpetrator-based. That is, it's the nationality of the person who committed the criminal act. They're the only state that gets a show at prosecuting the perpetrator, which is obviously manifestly inadequate if the perpetrator is a state agent. There's an outdated 1884 convention which deals with protection of submarine telegraph cables. There's a couple of recommendations by the International Cable Protection Committee, but nothing that really touches on this. And there are occasional resolutions by the International Telecommunications Union which do nothing either to advance our understanding of the regulation and jurisdiction in relation to undersea cables. Additionally, the 1884 Cable Convention, which is the only hard law we really have on this other than the Law of the Sea Convention, specifically says that the rules around protection of undersea data cables don't apply in armed conflict. So that raises a whole bunch of really interesting questions, like if a cable is neutral or belligerent depending on where it comes ashore at either end, well, that's one thing, but what is carried on the cable clearly is much more hard and much more difficult to identify as either neutral or belligerent traffic. And that's vital when you're thinking about whether you're going to take action against a particular cable. By comparison, there are several international agreements that cover the registration, jurisdiction, cooperation and offences in relation to space-based data assets, such as satellites. So this, to me, I think is quite a remarkable anomaly. We have a really strong regulatory regime for just over 2,100 satellites in near-Earth orbit. We have treaties, we have a UN Office of Outer Space Affairs, we have regular meetings on space regulatory issues and so on. But we have no security or protective focus regulation on the just over 400 undersea data cables on which 99% of data traffic and trillions of dollars worth of transactions every day are carried. This is really curious. So what might we do to fix that? Well, one option, I think, is to think about a suppression of unlawful activities at sea convention for data cables. So we already have one that deals with shipping. And this convention, called the Sewer Convention, deals with the use of ships in criminal activities, the use of ships in terrorist activities, but also offences against ships and offences in ships. It's a fairly widely ratified convention, and Australia has brought many of the aspects of that convention into our own domestic law. Perhaps something we need to think about is whether it's time to start talking about a sewer convention for data cables and the protection of data cables, because they are a trade by sea issue and they will require maritime forces to act in the protection of this critical piece of international infrastructure. So, where to from here? Well, in a physical and tangible and a kinetic sense, the legal aspects of maritime trade and their nexus with defence are pretty well settled and pretty well structured, although areas of debate do persist, and one of those of critical importance, which we're about to come up against again, is the precise legal basis for the use of force and protection of merchant ships through straits used for international navigation, particularly where those merchant ships don't fly our own flag. There are other areas of trade by sea, however, which are much more legally vulnerable, and these represent significant economic and security vulnerabilities as well. And I think that the lack of a robust regulatory regime around protection and management of undersea data cables is, I think, the case in point in that situation. Now, of course, we have to bear in mind always that in trying to fix some of these issues, we must remember that some legal gaps and some legal ambiguities are good. They're convenient. We want them to remain as legal gaps and ambiguities because that gives us area to manoeuvre. But by the same token, some of these challenges are really actually quite critical trade and security vulnerabilities, such as undersea cables. And perhaps what we need to be doing in terms of thinking about maritime trade is also doing some evolved thinking about the future trade by sea issues such as undersea cables and the defence implications of this critical vulnerability.